Hi, everyone. Welcome to this week's weekly live attorney chat here at Immigration for Couples. I'm attorney Megan Pastrana, and I am really excited to be with all of you. I see we already have a lot of individuals joining us here live. And good morning and hello to you as well. I always like to start out by asking, where is everybody at in the world? So, where are you at currently in the world, and where are you at in your immigration journey? So, are you just starting out? Are you in the middle of that journey? Or have you already reached the finish line? And I want to also let all of you know about the free resource center here at Immigration for Couples on our website, immigrationforcouples.com. We have a ton of free resources available to you. And I also created a free webinar. This webinar really goes into everything you need to know about the different options that are available to couples and how to prove your relationship and how to not just survive but thrive in your immigration journey. And I'm sorry, they are all of a sudden doing construction near my office, and it is loud for me. Hopefully, it is not loud or distracting for you. So let's see. I want to go to who we have here. So I'd ask, where are you at in the world? So good morning to you, Betty. It's great to have you back. And I know a lot of you know the drill. If you have questions, throw them in the comments and I will go over them in the order I receive them. And good morning, Anna. It's great to have you. All right. And I'm also going to check on my Instagram here and see if anyone else is joining us. Okay, great. And good morning to you as well, Vivian and Ginger. I think I saw you in here. I know I did. There you are. Good morning from the UK. All right. So I did have one topic that I want to go over with all of you, an update before I go into everybody's questions. And so there is an important update right now as it relates to COVID vaccines. So if you're watching this on the replay, if you're not here joining us for our weekly live immigration attorney chat at 11 a.m. Eastern time on Tuesdays, then please just do a hashtag replay and let me know where you're at in your immigration journey, where you're at in the world, and what your immigration questions are. And please do check out our free resource center at immigrationforcouples.com. So, what is going on with the COVID vaccine? So, during the pandemic, we had a COVID vaccine that came about as a result of the pandemic and the COVID virus, and the CDC, the Centers for Disease Control, and integrated or included that COVID vaccine as part of the vaccination requirements that are required for an immigrant who is going through a process to receive a green card. And so the CDC sets out the list of vaccines that are required, and anyone who is going through a process to receive a green card does have to complete a medical exam. And during this medical exam, that individual will receive vaccines if they don't already have them. And you take your vaccination records for the vaccines you've already received. And the CDC has that list of vaccinations, and the COVID vaccination was included on that list. Now, as of January 22nd, immigration made an announcement that the COVID vaccine is no longer required. And I know for a lot of individuals who did not want to receive the COVID vaccine, this comes as great news. And so, what does this mean if you are just in the middle of or just starting out on your immigration journey? This means that when you get to the medical exam component or requirement of your green card process, that you are not going to have to receive the COVID vaccine if you haven't already. And if you have received the COVID vaccine, that civil surgeon, that doctor that is certified by immigration is not going to require that you provide proof of your COVID vaccine. It also means that immigration is not going to send you a request for evidence or deny your application if you did not receive the COVID vaccine. The other thing that's important to understand is this is just specific to the COVID vaccine. It's only the COVID vaccine that's been removed from the list. All other vaccination requirements remain, such as tetanus, and everything else that is on that CDC list. All of those other vaccines are still going to be required. So I know we have a lot of individuals who are just now starting to join us live. And so I was just going over this new update with the COVID vaccine no longer being required. This is being recorded, so you can go back and watch it on the replay. And I am going to go ahead and dive in to everyone's questions here that I see popping up in the comments. And I do have I'm streaming this live rather on Facebook, LinkedIn, YouTube, and Instagram. And so as these questions are coming in, I'm answering them in the order I'm receiving them. And I'm definitely keeping an eye on Instagram because sometimes those questions won't come through, but I'll keep an eye on everyone. Okay, so your question is regarding photo evidence to support your spouse visa. And if you need photos of wedding with guests and any photos of you as a married couple. So, part of your immigration case, for those of you who are just starting out, is proving to immigration that you have a real relationship based on love. So that can, and if you're going through the fiance visa process, then that you have a real love, you have intentions of marriage, but that you have this real relationship based on love and not just to receive an immigration benefit. In my free resource center at immigrationforcouples.com, there is a relationship evidence guide, and I really dive into all aspects of relationship evidence. There's all kinds of different categories of relationship evidence, and it's not a one size fits all. So what I mean by that is every relationship is different. Every love story is unique. Your journey of love and your relationship story is different than someone else's. So the relationship evidence that you're going to provide will be different, of course. And there are different categories of evidence, and there's not like a set amount of photos that are required. Immigration doesn't say you have to send 10 photos and you have to send 10 text messages. They don't have quantity limits or an itemized list of what exactly that they expect that you are required to send. You are required to prove your relationship is real, and photos are a great way to prove that relationship is real. And photos, I've said this on many other lives and in other videos I've made, is it's about quality over quantity. So if you have 30 photos from your wedding day, that's great. But 30 photos, with a handful of those being from your wedding day and other photos being from different times in your life, maybe celebrations with families, trips that you've both taken, adventures that you've both had. If those are all different photos, different times, covering the entirety of really your relationship history, that's going to be stronger evidence. So if you're asking, though, your question is about including photos of your wedding. Yes, that's a really, really great idea to include photos of your wedding. And you need to make sure you have other evidence from all of the other evidence categories, like proof of communication, proof of time spent together, in addition to those wedding photos. Okay. Okay, so you have a similar question as well about the photo. So let me jump to your question here. Okay, so you cover your face during public gatherings for cultural reasons, and will immigration accept photos of both of you if your face is covered? Yeah, I mean, if those are photos of you at your wedding, if that's part of your culture, if that's part of the ceremony you celebrated, the answer really goes to what I said earlier of every relationship is different. Every application that is filed is different because you're going to be sharing your own unique story of love. So if that is part of your culture, then yes, immigration would accept that. And again, just as I said to Fatima about her question with wedding photos, it's really important to have all different kinds of relationship evidence, not just photos. So, all right, great question. Okay, and then okay, so for your question, what is the name you're supposed to write on your application? You always want to write your name on your application that is your legal name. So what is your name that is on your legal documents, like your passport? All right, and I have another question about relationship evidence with as it relates to text messages. So during your green card application process, how many text messages should I send? And that you have other strong evidence. Again, there's not going to be a set amount of text messages that you have to send. Immigration doesn't put in their instructions or rules or policy guidelines that they have to see 30 text messages. It is all about quality over quantity. You do want to give immigration enough text messages that they can see, that your relationship is bona fide, how your union has been nourished, how you both communication over time. That's really what they're looking for. So this is kind of like my photo example, where if you give 10 text messages all from the same month, that's not going to be as strong of evidence as if you'd have 10 text messages, over the course of a year, for example. So there's not a set amount. And it really does come down to making sure that you have, some text messages that cover the period of time of your relationship, photos, letters of support, other evidence that you're going to be including with that application to prove your relationship. Okay, so Fer, you said that your fiance came on a fiance visa. You're getting married soon. Well, congratulations. That's exciting. And I think you had told us that last time that you had the approval and that was your update. So that's awesome. Congratulations. Okay, so yes, after you file your fiance visa, then you are going to be filing your adjustment of status application. The adjustment of status application is taking your status from fiance visa to having a green card. That's the ultimate goal for anyone who is going through the marriage green card process, is to have that green card, is to have that permanent resident status, because that is what allows you to live and work and be fully integrated into life in the United States. So yes, the adjustment of status is what comes next. And along with that adjustment of status application, there is an optional travel permit and there's an optional work permit. And so if you can decide to apply for both of those, or you can decide that you only want to do, the green card application adjustment of status. I will say that what I tell my clients is that, this adjustment of status process and really any immigration process, wait times are fluid. It's kind of like riding a roller coaster. The wait times will go up and it'll be a long wait time. And then all of a sudden they'll go down. Recently, they tend to just keep going up in terms of wait time. So knowing that with your green card application, on average, it can take about a year to get through the green card application. Sometimes it can take longer. And we've definitely had unicorn cases that get approved in a matter of months. But the unknown, not knowing when you're going to have that marriage green card, it is really important to consider filing for that travel and work permit. So why would you file for the optional travel and work permit if they're optional and they cost an additional fee? Well, because during that entire time that you're waiting for your green card application, as the fiance visa applicant, you're not able to work and you're not able to travel internationally. So you're here with status, but not status that affords you the ability to do the things you need to do to live your life. So it's a really good idea to consider applying for that work and travel permit. There can be risks with traveling internationally. So even if you apply for it, definitely speak with an immigration attorney before traveling. But, it's really important to consider filing for both of those, because typically the work and the travel permit will come in faster. And right now we're at January 28th of 2025. I want to say that date because wait times change so much. So if you're watching this video on the replay months from now, wait times can be totally different. But what we're seeing right now as of today is on average work and travel permits being approved around the 4 to 6 month mark. Travel permits typically take a little longer, but in general, that's kind of the average of what we're seeing in terms of wait time. And yes, some immigration applications like the adjustment of status application can be submitted online. In general, though, if we have clients that are going to be applying for work and travel, we still file everything by paper. The online system can still be glitchy, but it is, it's kind of your prerogative on how you want to file that. All right. And yes, the work permit has a lower price for adjustment applicants, because individuals who are filing a work permit standalone on another basis, typically that fee is going to be higher. Whereas if you're filing with the adjustment of status, that work permit fee will be reduced. All right. Great question. I'm sure that was helpful to anyone else who's going through the fiance visa process too. Okay. So another fiance visa question. You got married. So congratulations, all of the fiance visa marriages. That's awesome. And you want to know if you can adjust overseas. So no, the adjustment of status application is a process that's completed within the United States. We do have individuals who, for numerous reasons, might need to be abroad temporarily, and so we can help with a travel permit to make that possible. But the adjustment of status process is something that happens in the U.S. If you'd like to talk in private about your particular situation and kind of your timeline and when you would be gone and things like that, we can talk about options for adjustment of status and making it viable for you to be able to be with your husband in Spain as well. So, but yes, the adjustment of status process does have to happen in the United States. All right. So I have a question about the National Visa Center and what documents are needed. This is definitely on the top 10 list of popular questions. And the answer is it depends. I know no one likes to hear it depends. You just want a list and you want to be able to collect it and get it submitted, but it does. The National Visa Center process where you're submitting all of your documents is going to be dependent upon your relationship history, were there prior marriages and divorces. It's going to depend on your civil documents. Some countries, there are two versions of the birth certificate, a short and long form version of the birth certificate you have to provide. And then if you had a name change, you would have certain name change documents that would be required. Every country is different. So like the United Kingdom, for example, if you ever had a name change, there's a couple different ways in the UK to change your name. And some of them, while acceptable in the UK, aren't acceptable by US immigration. So there would be additional documents you'd have to collect if you did a name change in the UK. So I'm just kind of giving you an example of why it depends and all of the factors on which it depends. The best thing to do is, if you have already received an approval on your petition, is to look at the instructions that the National Visa Center provides you and on the Department of State website, and go through their list of required documents and be sure that you're looking at country-specific requirements based on your country of citizenship and where you will be immigrating. And also, if you've spent time in other countries, you often will have to obtain police reports from those countries. So you can see it's just very, very specific on your immigration history, your relationship history, and your country where you're going to be processing. So check out the National Visa Center website. Okay. Yep. And Vivian, I just answered this question earlier for, I think it was fair, about like processing times. And I was saying we are here and January of 2025, wait times are always changing. It's not going to necessarily make your green card quicker if you apply for a work permit. The point of applying for a work permit is to have something that you can use temporarily while you're waiting for that green card. Because typically that green card sits at about a year. It definitely can take much longer or a little less time. It depends. And then the work permits are typically going to come in faster. We see here in January of 2025, on average, about 4 to 6 months for the work permit. So that's really the benefit of that work permit, is having that ability to work while you're waiting on a decision for your green card. I'm going to get some juice here while I look at the next question. I didn't bring my water in here, but I do have some juice so I can get a drink here. I've been talking a lot this morning with clients, and then here on the live, we have a lot of great questions. I'm going to read your question and get a drink. It's like an ocean spray commercial. Your petition was received by USCIS, and you're doing a lot of travel to the US until you get the visa. And you're asking about, if I'm understanding your question, you filed this petition, right? The fiancé visa petition. And then you are traveling to the US, be it on a tourist visa or ESTA. So this will go for anyone who is traveling internationally while a petition is pending, or traveling rather to the US while the petition is pending. And it's going to relate to your time in the US, right? On this visa or ESTA, like how long you're able to stay. So if you have ESTA, you're allowed to stay up to 90 days per entry. If you have a tourist visa, you're allowed to visit up to 6 months. The question is always, if I have a petition pending with immigration, like a fiance or spouse visa, am I legally allowed to come to the US on this tourist visa or ESTA? And the answer is yes, legally you're allowed to come to the United States and for a visit while that petition is pending. And it's important to understand that every time you're entering the US when you have a pending petition, and really anytime you're entering the US on a tourist visa or ESTA, that immigration officer is going to be looking at the circumstances surrounding your entry. They're going to be looking at, hey, are you coming on this tourist visa? Are you coming on ESTA really just with the intention for a short visit? Or do you have intentions to remain in the US and live? And so sometimes when you have that fiance or spouse visa petition, immigration agents are going to be suspicious and say, hey, you have this petition pending. Are you really just coming here, because you want to stay and live? And I know that's not your question, but I'd be remiss if I didn't share that for anyone else, because I know that's always a question that kind of comes along with how long you're able to stay. So you're able to come for trips up to 90 days or up to 6 months. And I'm not sure if you mean that you've been doing a lot of travel and the total days of all of those trips together is at 182 days, if that's what you mean. Or if you mean you have one trip. And I think you mean you've been doing a lot of travel. And so every time you enter, you're able to stay that period of time that's allotted by your visa or your ESTA. And immigration will look at your prior trips. And so if you've had a lot of frequent trips, if you've been spending a lot of time in the US, it could signal to immigration that they think you have the wrong intentions, that you're essentially coming frequently and living in the US and they can turn you away. While immigration has a rule that says, that you can't come for more than 6 months on your visa or you can't come for more than 90 days on ESTA, they don't have any bright line rules or laws that say how long, out of the calendar year or rolling 12, how long you can stay during that time. A good rule of thumb is to be staying less than half the time. So if you had that tourist visa, a good rule of thumb is in a rolling 12-month period or in a calendar year that in total that you're spending 6 months. Is it possible to come for more trips? Yes. And every time you enter, again, it's going to be immigration, looking at the circumstances of your entry. So is it a red flag? Not necessarily a red flag for your petition, but can it be a red flag to the immigration officers when you're entering the country that you've been coming a lot? Yes. And you should be prepared, to answer questions and have them question whether or not you're coming just for a visit. Or if they think that if they have concerns that you're coming to stay. So I know that's it's a lot of information, but it's a complex question. And it's like so many things in immigration, it's going to depend. It's going to depend on how long your petition has been pending. It's going to depend on when you took those other trips, how long those other trips were. And it's going to depend on a lot of factors, including, do you have things in your country that are pulling you back out of the US that you can show to immigration? Hey, look, I'm just here for a short visit and I have to report back to work, for example. So, yes, it is going to raise flags if you have a lot of trips, and then just being prepared to answer those questions and show your ties outside of the US. I hope that helps. I know it's a question that a lot of clients ask, and we really have to walk through the question with that individual and their specific situation to say whether or not a trip is advisable or when their next trip would be, be possible. Yeah. Okay, good. I'm glad that was helpful. And if you can show return flights, yes, you should always have that return flight. That does help. And then any other evidence, that proves that you are being pulled back home. So I'm glad that was helpful. So Rusty, you are asking about embassy closure and how long they've stayed closed. It seems they had a knee-jerk reaction to the U.S. Embassy in Colombia and closed for all appointments. So yes, I've definitely worked in immigration for a long time and have seen embassy closures and, transferring of cases. And it really is going to depend on what other U.S. embassies are able to step up and absorb those cases, or if that closure is just one of those, temporary closures, which is what we're hoping in this situation. I wish I could give an exact time on what we will see in terms of when that would reopen. In cases where embassies close and then they close for a long period of time, or they close indefinitely, typically what's going to happen is that another U.S. embassy or consulate will step up and be willing to absorb those cases and take on interviews. So looking at, other countries where an individual can interview is what we would do, for our clients. So the U.S. embassy, for example, in Russia, when that was closed, and then cases, it took a while before Warsaw, Poland, was able to step up and start taking those cases and that be the designated post. And in the interim, after that closure, then we were reaching out to other embassies and consulates across the world, asking to transfer the cases so we could get our clients in for an interview and keep their process moving, even though that closure was happening. So yeah, it'll depend. Like everything, like that's kind of the theme with immigrations, is it really depends. Hopefully this will be a short closure or a short cancellation of appointments, and things can resume as normal soon. Good morning to you as well, Hamida. You're very welcome. Yeah. Okay. This is yeah, a difficult situation, and a hard question, right? About the change in administration, and will the change in administration make it harder for visas to be approved? And so the answer really is, having practiced previously under the Trump administration, seeing what they have in terms of plans for immigration. I know a lot of the focus at present, seems to be on the border and birthright citizenship. However, the Trump administration, this current administration's agenda is really about making immigration more difficult in general. And one of the things we saw previously under the Trump administration, and one of the things that American Immigration Lawyers Association has said, and we as by we I mean myself and all of my colleagues who practice immigration, what we do expect to see is a repeat of some of those very strict standards in terms of more thorough vetting. You are right. Immigration has a long list of red flags. These are actually red flags that are part of the immigration officers manual. Like when they are trained to be immigration officers, the red flags that they should look for, and countries are actually in that list. So Nigeria is one of those countries that U.S. immigration has determined to be a high fraud country. And so those applications are scrutinized more closely. And so you're definitely right about that. And yes, this current administration, as they have said before, and like I was saying, the American Immigration Lawyers Association, we anticipate that they are going to have more thorough vetting, be more strict. Some of the things that we would see during the prior Trump administration is that, and I know this is for your spouse visa, but one of the things that we saw was for adjustment of status cases. And in a lot of adjustment of status cases, as long as you file your application properly, as long as you have a strong application, it is possible to get your interview waived for adjustment of status. Under the Trump administration, they brought in a policy that said everyone had to be interviewed no matter what. There was no waivers of interviews. So that created a backlog, and that created very long wait times for individuals to receive an interview and an ultimate decision on their case. And that was part of that more strict scrutiny, having officers look more closely at cases. And we definitely saw an uptick in requests for evidence on applications for fiancés and spouses, really all of the family-based immigration cases wanting more relationship evidence, even in situations where there was very, very strong relationship evidence like children in common. So yes, and I never want to fearmonger. If you have watched or followed any of our content at Immigration for Couples, we're all about educating and empowering. And we don't want you to be paralyzed by fear. I want you to be aware and educated. So, okay, we are in an administration that's not necessarily immigrant friendly, and they are making more strict requirements. What are the things, now let's move to an empowerment. What are the things that I can do, as an individual going through this process to be prepared, and to have the strongest case possible? So making sure you have really solid relationship evidence, making sure you submit a strong application, hiring an immigration attorney. I promise I'm not just saying that because I'm an immigration attorney. Having an immigration attorney who's an expert, who has done this. My team and I, we've done this thousands of times. And, for you, if this is your first and hopefully only immigration case, leveraging that expertise of a professional who can help guide you and put you in the best position possible for an approval is something else, that you can consider doing if you don't already. All right. All right, so I can do a few more questions. We have so many people watching live and so many great questions, and I will do my best to try to do one or two more here. And I was just checking out here on Instagram because sometimes those questions don't come through. I see we have a lot of individuals joining, so welcome. And again, for all of those of you who are just now joining, I encourage you to check out the free resource center that my team made. It's at immigrationforcouples.com. We have a free relationship evidence guide. So if you're just starting out, that's a really great place to look as our free resource center, understand what immigration is going to be looking for in terms of relationship evidence. We have charts that give overviews of the different processes. And then I also have a webinar where I really dive into the options that are available for couples and how to go through that immigration process successfully. All right. And so Nancy on Instagram is asking about filing an I-130 in March of 2024, and her spouse lives in Nigeria. Will changing his interview to Ghana expedite the process? So I am not sure if you already have an approval on your I-130 petition. Typically, those I-130 petitions are taking well over a year right now, on average 15 months to get an approval on the I-130. So I don't know if you have that yet. If you don't, then your case is still with USCIS, and transferring it to another embassy isn't going to expedite that I-130, because right now your case is with the USCIS. Okay, so you just said no. So your case is still with USCIS. So trying to change interview locations is not going to expedite the decision on that I-130, because your case is with USCIS in the US. It's not at the embassy yet. Can you select a different consular post for your interview? Yes, each U.S. embassy and consulate has different requirements for their particular post and who is able to have interviews there. Yes, Nigeria has long wait times for an interview, but so does Ghana. So definitely be careful if you're going to be trying to, transfer your case to a different country, and making sure you're not trading one long line for another long or longer line. Okay, so I'm going to try to answer, let's see, one more question here I think I can do. Hi, Thomas. It's nice to see you again. I know you've been on our lives before. Okay. Oh, yay, you got your interview. That's great. Okay, perfect. Well, good. I know you've been waiting on that. I know you had brought up questions about interview scheduling before, so that's fantastic. Congratulations, and glad you got your medical exam done. So the interview itself, typically it's about a 10 to 15 minute interview. Again, it'll just really depend on your case. Some officers will take a little less time, some need more time. On average, they are going to review your application and all of your information before the interview, and they typically have a decision and the questions that they need to ask you beforehand. But I usually tell my clients, be prepared for about a 10 to 15 minute interview with the questions that they'll be asking about your immigration history and relationship. It's a very important day, so be sure to be prepared. I know you will, and I know you've been waiting for that interview, so congratulations. We're all celebrating you. That's wonderful. Oh, Annette, you're joining a little late today. That's okay. Better late than never. Glad to have you. If your girlfriend gets an I-10, which is an individual tax identification number, would it affect your immigration status? So it's important to understand that individual tax identification numbers, social security numbers, that is related to the IRS and taxes. And then for immigration purposes, that I-10 is really not going to come into play. So would it affect your immigration status? No, because an I-10 does not give you any kind of immigration status. It doesn't give you any kind of immigration benefits. That I-10 number is solely for tax-related IRS purposes. All right. I wish I could get to all all of your questions here today. They've been great. I am going to go through them. Like I say at the end of every live, when I can't get through all of the questions, I still go through all of them afterwards, and then I make videos on those topics. Sometimes I will go through and see questions and bring them to the next live and answer your questions at the next live. But please do join us. Again, I'll be here next week, Tuesday at 11 a.m. Eastern time, to answer your questions live. It's been great spending this time with all of you. Take care of yourselves, and I will see you soon, and best of luck with your cases. All right. Take care, everyone. Bye.